morning, Mr. Director. Good morning, learned judges. I see I'm 15 minutes late. I hope someone has asked for a passover on my behalf. I'm sorry, I reached very late last night, and then I had, of course, to address a gathering like you. I had to educate myself a little. So that took some time. So I'm really sorry that I'm a little late. I would like to be on time usually. The topic with which we are today concerned is intellectual property. And as you're all aware, intellectual property in India broadly concerns 4 different statutes. Of course, the Trademarks Act, the Copyright Act, the Designs Act, and the Patent Act. Now, so far as these acts are concerned, they are distinct and yet they are intertwined in a sense. And as we go along our journey of discovering, what these statutes offer in terms of recourse when rights are infringed, we will also see as to how there is a connection between these statutes. Of course, when we talk about intellectual property, the first and foremost thing that usually engages judicial attention is the Trademarks Act. Now, for that we have to understand what is a trademark. Before I go into the statutes, before I go into the sections, before I go into judgments, just very briefly, trademark is something that is used to distinguish a product or a service. So therefore, trademarks usually have to have, normally, that element of distinctiveness. And so when we talk about trademarks, at the first instance we talk about trademarks which are capable of distinguishing a particular product or a particular service without reference to anything else, because that gives it that element of novelty, that element of distinctiveness. For example, Kit Kat. It means nothing. Yet today it has become synonymous with chocolates. For example, Volvo. It means nothing. But it has become synonymous with cars today, a particular make of cars. So therefore, usually when we look at trademarks, we look at something that identifies a particular product by reason of the distinctive name that is attached to the trade or to the product. However, very often we also find that there is no distinctiveness in many of the trademarks that have come to be used. Now you find green ply. The word green is not distinctive, the word ply is not distinctive. They are common words which are used in parlance. Then how does one distinguish a product on the basis of these words? There we come to ultimately a combination of words. Green and ply taken together. Green by itself is not capable of distinguishing anything. Ply by itself is not capable of distinguishing anything. But when you combine green ply together and you apply it to a product, then you seek to identify that particular product by the combination of these words. And very often we also find that to ultimately buttress the right to a trademark, we find that apart from word marks, we also have device marks or label marks, what we usually call trade dress. So you'll find that the Kit Kat wrapper is very distinctive. It has that red and white combination. You'll find gold flake cigarettes are very distinctive. Now again, gold taken by itself is not capable of distinguishing anything. Flake by itself is not capable of distinguishing. But gold flake brought together distinguishes a particular brand of cigarettes. So therefore, ultimately, apart from the word marks that we normally come to see, we also find trade dresses, label marks, device marks. And trade dresses, label marks or device marks are also independently capable of being registered. They also are capable of ultimately conferring an element of distinctiveness to the product. So we find that apart from the word mark gold flake, we also have gold flake registration of labels, different labels, which by virtue of the font or the stylized manner of writing the word gold flake, or by reason of the color combination, or by reason of the conjunction of words below a particular color combination or the arrangement of words on the packet or the label, it comes to become distinctive. Now, when we talk about the packet or the container in which the cigarette is sold, we are talking about a particular kind of packaging. Now, normally you find all the cigarette packets are hinged, they open from the top closed. But normally you also find that, for example, bottles in which alcohol is sold, For example, the Grey Goose vodka, it comes in a tall bottle. Why the tall bottle? Is it meant to contain more alcohol? No. It is ultimately to give a design, a shape, a color combination to distinguish, to identify that particular product. Now what we are trying to say here is an attempt consciously in the trade to ultimately associate a product with a particular set of identities. It can be a name, it can be a design, it can be a combination of both, and it can be otherwise a graphical representation. Now when we talk about design, for example, if you look at different bottles of whiskey, Hibiki whiskey comes in a particular bottle. Now that bottle has been registered for its design. You can't copy that design. Grey Goose, the particular bottle, it is identified for its design. It is registered as a design. You can't copy it. So we have a combination of factors. We have the trademark, that is the word, Grey Goose. Now again, please see, grey by itself and goose by itself, not distinctive. But when you take grey and goose together, they distinguish a product. Now you apply it to a bottle. The bottle is in itself very distinctive. The bottle has a particular label. That label is distinguished. So what do we have? We have a trademark. We have a copyright on the artistic work on the bottle. And we have a design registration on the bottle itself. One is three-dimensional, that is the design. One is the artistic work, which comes both within the fold of a label work within the Trademarks Act, and also it is by itself an artistic work which is capable of protection under the Copyright Act. So we have all these factors which ultimately come together. So we see how the Trademarks Act, the Copyright Act and the Design Act complement each other. And this is how we see these acts ultimately offer a protection to the trading person. Now this protection has become very important in today's world, because in the commercial world what we see is that institutes or companies or organizations spend millions of dollars to promote a product. Now when we talk about promoting a product, it is to build up the brand, it is to build up the image. It is to ultimately say that my product is the best in the market. And so therefore we also have companies which are coming forward to ultimately demonstrate that they have spent millions in advertising, they have generated very high volume of sales, and today if a third person comes and tries to cash in on their goodwill or their reputation in the particular product, then they will suffer a loss. So ultimately we tie it up with the concept of loss in the industry. So it is to protect an entity which has acquired a right from this loss aspect. Now when we talk about a right, let us understand how the right emanates. Do you always have to seek the protection of the Trademarks Act to seek to protect the right over a trademark? Trademarks Act, if you see by the schematic pattern of its section, it really seeks to protect infringement actions. So when you have a registration over a trademark and someone seeks to violate that registered trademark, at that point of time you can go to court and seek an injunction saying that no, restrain him from doing so. But even if you don't have a registered trademark, it is possible to seek trademark protection. Now very important, sorry, you're saying something, ma'am?
Goodwill.
Yes. Goodwill, reputation, all of this. Now very important is that if I have, let us say, a registered mark, a particular registered mark, let us say, for example, just to take a random word, gold flake. I have registration over the word gold flake. But someone else has been using gold flake even before I applied for and obtained registration. So that someone else is a prior user. Now when we talk about a prior user, that prior user has primacy over a registered user. So for example, if I come to court and I have a registration and say that look, X or Y or Z is trying to copy my registered mark, that X or Y or Z can come to court and say that no, you can't seek to injunct me because I am a prior user and I have a greater right than the registered user. So therefore, that is one of the defenses to an action. So what I am trying to say is there are two types of protections available to trademarks. One is the protection that is given by the statute, the Trademarks Act. And one is the protection of the common law. It's a common law protection of prior user. That is a tort. It's a civil law. If today I have been using a particular trademark and I have been running my business with that mark and it is in the course of use acquired goodwill, it has acquired reputation, then you can't come and today suddenly say that no, I will feed off your goodwill. Today you can say that I have obtained a registration, I'm entitled to protection, but yes, that will protect you against everyone else, but not against the prior user. And prior user is something that you will not find very well defined in the Trademarks Act, because it does not seek to protect prior use. Because prior use is a common law right, which is available to every trader who has ultimately traded on the goodwill and reputation. Now there are various facets of the mark. When we talk about trademarks, we are talking about therefore marks which are capable of protection. There are certain marks which are not capable of protection. For example, today I can't say that I am trading on the words, let us say carriage, which is a word, common word in daily use, which has not any capability of distinguishing any particular product. The question is, will carriage be capable of protection? Now, if I use carriage for identifying a taxi service, or if I use carriage for identifying an auto service, then that will not be capable of protection, because that has nothing to distinguish it from the product that it is offering. It is identifying itself with the service, with the product that is on offer, not capable of distinguishing. But if I use carriage, let us say for selling tea, then there is no trade association between the two. Then I can use carriage to distinguish tea, because there is no association. Now it is with this background that one has to look at what kind of protection is still available. Now, for example, let us also say that the common example is that there is a word in Tamil called Enadu. Enadu in Tamil means today. Enadu is a popular newspaper, and someone tried to use Enadu for another product. Enadu by itself is not capable of distinguishing anything, because it means today. Now when the court was confronted with this question, the court said yes, it means today. It is not generally capable of distinguishing anything, but by long, continuous user, it has acquired an independent goodwill and reputation. And when it has acquired such an independent goodwill and reputation, it has transgressed these normal boundaries of distinctiveness, etc., because it has become associated with the continuous use of this word with the particular trade. And then it says, notwithstanding the fact that Enadu is not capable of ultimately distinguishing the newspaper that it is selling, because it means today, by reason of long and continuous use, it has become entitled. There are several such instances. We call this also something which is known as a well-known trademark. Now normally, a trademark is capable of ultimately being associated only with the product for which the trademark is used or is registered. For example, Kit Kat, used for chocolates. We have not seen Kit Kat used for soaps or for linen or for any other thing. So Kit Kat in its identification to chocolates has acquired goodwill and reputation. I had the occasion of trying to appear to defend the Kit Kat mark for the Kit Kat chocolate manufacturers against someone who was manufacturing Kit Kat chanachur. And the court said, no, I'm sorry, but you will not be able to ultimately say that I have a monopoly over the word Kit Kat for every and all kinds of product. And that is also what the statute says. So ultimately what I'm trying to say is that a registration of a particular trademark does not transcend all boundaries. It is usually confined to the product for which it is registered. So if we today try to say that yes, I have a registration of the word Kit Kat and you can't use Kit Kat for soaps, or you can't use Kit Kat for chanachur, then I will not be permitted to so unless, and this is where I was a little aggrieved. I had thought of appealing, but the client said no, let it be. Unless the mark has acquired what we know is the character of a well-known trademark. When we talk about a well-known trademark, then again it transcends these boundaries. Now, a well-known trademark ultimately says that it will be capable of registration notwithstanding the fact that it does not confer distinctiveness. And a well-known trademark also says that because it has become well-known and it has in some cases what we call acquired trans-border reputation, you can't really sell any other product using that mark. For example, Mercedes. Now today Mercedes is used for cars, Now in India, if I suddenly start selling Mercedes towels, then that is something that can be resisted. Because Mercedes has acquired a well-known trademark categorization, and it has acquired that kind of distinctiveness and reputation. So you're basically trying to cash in on that goodwill and that reputation. Now it is with this background that we have to examine that what is now really the correlation between the Trademarks Act and the Copyright Act. The Copyright Act is not really very different from the Trademarks Act. It only extends beyond the normal boundaries of what the Trademark Act protects. The Trademark Act protects trademarks. What is the trademark is defined in the Act. The Copyright Act goes beyond and also gives protection to artistic works, to cinematographic works, to music works, to literary works. So it gives the same kind of protection but to works. Now copyright is a protection, it is not the right to copy. So the copyright is that I have acquired a copyright over a particular mark, which is an artistic work, and it is that artistic work that ultimately is confused with the label mark or a label design. It is more or less the same thing. You can obtain independent copyright registrations as also label registrations under the Trademarks Act. So a copyright is a same manner of protection that is afforded to artistic works. It can be a label, it can be a music composition, it can be a painting, it can be a literary work, so on and so forth. And otherwise, these acts really ultimately traverse in the same trajectory and ultimately seek to offer the same kinds of protections, with minor deviations here and there because of the character of protection that it seeks to afford. And so far as the Designs Act is concerned, I have said that design is also ultimately protection given to normally a 3D dimensional design. It can be a bottle, it can be a packet, it can be a design of a machinery, it can be the design of a building, it can be design of a structure, it can be design of a car, it can be design of a scooter. So all these are capable of protection, because today, if you look at the cars, they are coming out with very distinctive grills in the front. The idea of having these distinctive grills is to give it that element of distinction. So if someone comes and copies that grill, then there has to be something to protect against that copying, because that grill has been devised, it has been conceived, it has been put into execution, it has acquired a three-dimensional shape or character, and ultimately it is something that is ultimately used to also promote the product to which it is applied. Now these are the basic facets of these acts. I shall of course delve deeper into the aspects of these acts, and particularly the Trademarks Act, particularly to the extent that it will concern judicial professionals. Because what we are usually confronted with is when a person comes complaining of an infringement of a trademark, the person comes and asks first for an order of injunction. The question is, when can the injunction be granted, when should it not be granted, what are the factors which will normally ultimately attach to the principles governing the grant of injunction in case of intellectual properties. And then of course the second thing that is asked for is, at times you find that you don't know who is your adversary, who is copying the product. Then you ask for something called a John Doe injunction. It is against the whole world, whoever may be found to be copied. So all these facets are various nuances of these acts and their applications. But otherwise, this is the broad scheme. Now before I start taking you all through some of the facets of the act and discussing them in some greater details, is there anything in particular that any of you would like to ask, so that I can focus on that? Because if there are any particular problems that you have envisaged in the course of ultimately entertaining such applications or considering them, then I would like to approach it from that perspective, that viewpoint. I don't think anyone has any particular question, so we just start with the Trademarks Act once. If all of you have the Trademarks Act available, may I request you to just take up the copy. I'll first come to definition of a mark, because you'll find that the word mark and the word trademark are defined separately in the Trademark Act. Please see section 2, which is a section which talks about the definitions, and come to section 2M. Section 2M defines a mark, and it says a mark includes a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging or combination of colors or any combination there. So it's very, very wide. A mark includes everything. But then there's a distinction between a mark and a trademark. If you now come to section 2ZH. Trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, and may include shape of goods, their packaging, combination of colors, etc. And then there are various other provisions which I don't think I need to trouble you with at this moment. This is the broad definition of a trademark. So ultimately a mark may be anything, but a trademark has to be something that is capable of being represented graphically, and it is capable of distinguishing goods or services of one person from those of the other. Now, after that, let me also take you to the concept of a well-known trademark. Please have a look at ZG, section 2ZG. Well-known trademark in relation to any goods or services means a mark which has become sold to the substantial segment of the public which uses such goods or receives such services. So may I just pause here for a moment? So here the section seems to suggest that you will be a well-known trademark if you are well-known within the particular segment of the service or segment of the people who use your services or use your products is concerned. Please look at it again. Well-known trademark in relation to any goods or services means a mark which has become sold to the substantial segment of the public which uses such goods or receives such services, that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those goods or services and the person using the mark in relation to the first mentioned goods or services. Now, let's understand what this section really says. What this section says is, in the first instance, that it is well known if it is ultimately well known to a substantial segment of the public which uses such goods or services. But then again it goes on to say, such that the use would be likely to be taken as indicating a connection in the course of trade or rendering of services between those goods or services and a person using the mark in relation to the first mentioned goods. So ultimately, if a mark is so well known that if anyone else uses that mark, it would seem that it is coming out from that house. Let us say the house of Birlas, or the house of Reliance, or the house of Mercedes, or the house of Sanyang, so on and so forth. So ultimately, the distinction that this section makes is it may acquire well-known, it will acquire the character of a well-known mark in relation to a particular product, Mercedes in the case of cars. But if you today try to apply Mercedes to anything else, then one would get the impression, is it from the same manufacturer? Is it from the same stable? So therefore, that is the distinctive right that a well-known trademark enjoys. It enjoys a higher category of right than an ordinary mark. So what we have is a mark, we have a trademark, and we have a well-known trademark. Now, so far as this is concerned, the question is, when does it ultimately become susceptible to challenge? Now I'd like you to please have a look at section 2H. Section 2H describes or defines deceptively similar. A mark shall be deemed to be deceptively similar to another mark if it so nearly resembles the other mark as to be likely to deceive or cause confusion. Now, what according to you, any of you, can you say what according to you would be the first element of deception? Have you come across any of the marks recently that would say that, oh, I find that this is a copy, this is a deceiving copy, this is a confusing copy, this is misleading, this is an attempt to cash in on goodwill?
In Delhi, I've come across a water bottle with bill saving.
Yes.
This lady.
There was a case of alcohol bottle, I think, with honeybee, and there was another bottle of honey gold. It was a similar design, similar color panel, similar font and everything. So it's like honey gold and honeybee.
Both are absolutely opposite examples. So far as Judiciary is concerned, we all know the Judiciary has acquired a reputation in packaged drinking water. Now when you say Bilseri, it's obviously someone is trying to cash in on the goodwill of Judiciary. Now when we talk about that, I'm so happy that you have come up with these two examples. Let us take the case of Judiciary first. Now when you come up and you buy a bottle of water, what do you normally see? You normally see the same kind of label. Not everyone looks with great scrutiny into how it is spelled. And that is where it is an attempt to ultimately cash in on the goodwill. This is called dishonest intention in the adoption of a mark. And normally, when you learn a judges come across a situation, you would look, when looking for an act which is infringing, as to whether the intention is dishonest. The question that you would then ask yourselves is, why did he have to acquire the same number of letters, just rearrange them and come up with a word which is similar sounding? And when you're looking at this, you're looking at the general kind of public who will be ultimately buying this product. Now when a person, he's traveling on the road, says, give me a bottle of mineral water, and says, Bisleri, yes, good, let me take it. And without closer scrutiny, he buys it. It is also more or less similarly priced. The bottle shape and configuration is more or less similar, the cap is similar, the label is similarly colored. So you are misled. But when you come to bottles of alcohol, there is a slight distinction. Very important distinction. Today, when a person is going to buy a bottle of whiskey or a bottle of brandy, honey wheated for example, and you look at the bottle, you look at the color combination, you look at the label, then the question would be, A, is it similarly priced? B, for a discerning customer who knows what brand of brandy he wants to buy, will he be misled? Will he not look into it a little closely? Because we are not talking about the class of customers who would normally buy the product. We are now talking about a discerning customer. For example, if today a car was to come out with the words Mercedes rearranged, then the question is, would you look into it more closely to see, are you buying the same Mercedes or Mercedes? So when we are talking about passing off, when we are talking about an attempt to cash in on the goodwill, when you are talking about misleading the public, because that is the element which says deceptively similar, it must be capable of causing confusion, it must be capable of deceiving. Then you are looking at it from the perspective of the buyer. Is it going to be a buyer who is discerning, or is it going to be a random buyer? For example, if you are looking at a packet of cigarettes which are more or less similarly colored in packaging, but one costs maybe 30 rupees per stick and one costs 10 rupees per stick, then again the question is that, are you going to be misled so easily? So that is one of the tests that one usually applies to find out as to whether it is deceiving. But then again, that is not an absolute test. Because at the end of the day, you are still going to see as to whether there is a dishonest intention. Whether, even if you are going to try to pass off a product, for example, just to take an example here, let us say that today I am used to buying a particular brand of cigarettes at 30 rupees a stick, and I find that the same brand or something similar is available for 10 rupees. I might go in for the cheaper variety thinking it is from the same house or same source of manufacture. So all these factors become very relevant. So when we are talking about deceptively similar, We are talking about what is capable of deceiving the customer at the first instance. But that is not where the courts have stopped. Because ultimately, our judiciary in our country has evolved. And it has said, no, we are not going to confine ourselves only to the case of a person being confused. Maybe he is not confused now, but maybe there's scope for confusion. So we will not look at only that. We will look at whether there is ocular similarity, that if I see the two products, whether they appear to be similar, whether there is phonetic similarity, whether they sound similar. And if today it is ocularly and phonetically similar, then usually the court at the first instance will grant an injunction. And what is very distinctive in the case of intellectual property is that when the court proceeds to grant an injunction, the courts have held now that normally when we ask for an injunction, we can't come to the court panting. A great wrong is being caused to me, please immediately protect my right. But in the case of intellectual property, the courts have said no, delay is not a factor. Even if you come after a delay, I will protect you, provided. In the meantime, you have not allowed someone else, with your knowledge, to build up a business in a brand which is similar to yours and have acquired some reputation in itself. So that is where the doctrine of acquiescence comes in. If you acquiesce to someone else, ultimately, trading on in a particular product which may not be identical to your product but may be similar. Because the two words which you will find continuously in this act are identity and similarity. Identity is absolutely similar. Similarity is not absolutely identical but something similar. So then you talk about acquiescence. So one of the defenses that we normally come across is say that look, you knew that I was carrying on this trade and I was doing it for a long time, and over the years you have allowed me to build up an independent reputation in the product. And I have a huge customer base. I have also spent substantially in advertising. How can you today come and seek an injunction against me? That is again where the question of deceptive similarity would perhaps take a step back. So we have these definitions normally within which we find that there is some interaction. So a trademark may be a well-known trademark, may not be a well-known trademark. A trademark nonetheless would be entitled to protection. A well-known trademark would be entitled to protection beyond the limitations that are imposed on the protection that is available to trademark simpliciter. Deceptive similarity is something that ultimately will proceed to deceive customers, but deceptive similarity is not by itself always an absolute proposition. Even if you find that yes, there is no deception as of now, but there is capable of deception in future, in that case also, the courts will step in to grant injunction. There are, however, some kinds of trademarks which ultimately you will find have become very well known, but too well known. Now what do we say when we talk about that? When a trademark has become so well known that it becomes a household word. Xerox. Yes. Hawaii chappal for slippers. Hawaii is a trademark that Bata had registered. But then every rubber slipper that is attached to the foot by thongs is known as Hawaii chappal. So that's when it becomes publici juris. It becomes available to the public. And then I may have registered the word Krishna. It's the name of a Hindu god. Now are you capable of saying that I will exercise a monopoly over this word? So there also the doctrine of publici juris has been attracted. So Xerox, Hawaii chappals, or something else will come similarly. But you see, when you talk about Kentucky fried chicken, Kentucky by itself not good enough. Fried, not good enough. Chicken, not good enough. Take it together, it becomes a trademark. And that is how it has worked, and that is how business has evolved over the years. So this is where we talk about trademarks. Now we come to section 9 of the Trademarks Act, which is ultimately saying that what is a mark that can receive protection and what is a mark that will not. Please have a look at section 9. Section 9, and section 11 will have to be considered together, but let us read the section first. Section 9 talks about absolute ground for refusal of registration. Let us read the section first. The trademarks A, which are devoid of any distinctive character, that is to say, not capable of distinguishing the goods or services of one person from those of another person. B, which consist exclusively of marks or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin, or the time of production of the goods, or rendering the service or other characteristics of the goods or service. C, which consists exclusively of marks or indications which have become customary in the current language or in the bona fide and established practices of trade, provided that a trademark shall not be refused registration if before the date of application for registration it has acquired a distinctive character as a result of the use made of it or is a well-known trademark. So, when will you refuse registration? Normally, the system is that you take a trademark application, you file it with the registrar makes a publication of that application, seeks opposition to the application. If a person says that no, I already have a registration of this kind of a mark, or I'm a prior user in this kind, I can come and oppose the registration. Then the opposition is taken up for scrutiny before the registrar. The registrar looks at the opposition and then decides whether it is capable of registration. Now, in the course of opposing a trademark, one can very well come and say, it is not distinctive. It is devoid of any distinctive character. It is not capable of distinguishing the goods or services of one person from those of another. And please see subsection B of section 9. It says, which may serve to designate the kind, quality, quantity. Now, when we talk about kind, we say, for example, the kind may be first flush in teas. Kind. Quality. It's gold class. Champion. Diamond. Brilliance. These are adjectives which we use to ultimately give the product a lift. It is called buffing up the product. These are laudatory expressions. These are expressions which are ultimately attached to a mark to give it a lift in the eyes of the consuming public. And when we talk about intended purpose, for example, if you say clean, use the word clean in respect of a detergent. Purpose. So these words by themselves will not be capable of distinguishing any product or any service. Today, for example, I am a dry cleaner. I say dry clean. Dry clean by itself is not capable of distinguishing. But then I have to attach a prefix or a suffix. For example, let us say X dry cleaning or dry cleaning by X. Then, together taken as a whole, it becomes capable of giving some distinction. But dry clean by itself will not be enough to distinguish the product or the service. And geographical origin, when we talk about geographical origin, of course, there is a separate concept of registering geographical marks. For example, you know that Darjeeling teas have now received the GI identification. So although it ultimately reflects origin from a particular source or a place or a geographical location, today Darjeeling teas has become capable of protection. Or for example, if you take Rasagulla for West Bengal, it has received the GI indicator. It has become identified with the place. So Rasagulla would mean this sweet emanates from West Bengal. There have been several such products which have ultimately received geographical indicator characters, and these are therefore capable of distinction. So even within the parameters of this section 9, there is ultimately a room for some play in the joints, some play in the elbow. And so there are differences that when a particular crop or a product or a service is so strongly related to a particular place that it is capable of being identified with that place, with the name, because people are going to look for teas that come from Darjeeling. And so therefore you can't use Darjeeling teas for anything but for teas that are produced of Darjeeling. Now if you similarly look at, while we are looking at section 9, if you also have a look at section 11. Now section 11 is interesting because it says relative grounds. Section 9 is absolute ground for refusing registration. Section 11 is relative grounds for refusing registration. So we are now talking in the context of sections 9 and 11 about products which cannot be registered at all, or trademarks which cannot be registered at all, or which for trademarks which may be or may not be registered. Not registered at all will fall within section 9, may or may not be registered will come within the ambit of section 11. Now I would request you to please have a look at section 11. Save as provided in section 12, a trademark shall not be registered if because of A, its identity with an earlier trademark and similarity of goods or services covered by the trademark, or B, its similarity to an earlier trademark and identity or similarity with the goods or services covered by the trademark, there exists a likelihood of confusion on the part of the public, which includes likelihood of association with the earlier trademark. So here, section 11 essentially says that if there is an earlier trademark registered, or earlier trademark existing, or earlier trademark which is known to the public, in that case you will not allow a similar trademark to be registered for the same product. Please also notice the use of the language here. Section 11A says its identity with an earlier trademark, identity would be absolute similarity, and similarity of goods and services covered by the trademark. So, two things: the mark and the product for which it is used. Identity of one mark with an earlier mark, and it has to also identify with the product for which the mark is being used. B, it just reverses the language. It's similarity, not identity, similarity to an earlier trademark, and the identity or similarity of goods and services covered by the mark. So in both cases we have, of course it's a play of words, but that is how the legislature seeks to protect all eventualities. It says identical mark or similar mark, attached to identical or similar goods. And if you find that there is an existence such a situation, you will refuse registration. That is a relative ground for refusing registration. Now if today, the question, why does it assume importance? Today, for example, if you find that there is ground for refusing registration, a mark should not have been registered at all, but still it has been registered. What do you do? Now there have been so many instances where we have come up with situations where a person has gone and obtained registration of a mark without proper opposition, without proper scrutiny, without proper reflection, without due application of mind, and the mark has been registered. Now I come up with a mark of my own, which ultimately, to an extent, may cover the other mark which has been in existence or has been registered. And I find myself in a quandary because although the other mark should never have been registered, it is on the register. And so long as it is in the register, it is entitled to the protection of the Trademarks Act. And although I have legitimately come up with a mark which may have an element of the earlier mark which has been wrongly registered, I can do nothing about it. So what do I have to do? I have to go before the registrar because the courts have no jurisdiction in this regard. I have to apply for cancellation of the mark. The registrar will entertain my cancellation application, call for opposition, go for a detailed hearing, then go into the question as to whether the mark should have been registered in the first place. And till that time, I sit quietly. Now here, this is also a case that I am going to present before you. This had become a matter of great controversy. That today the court finds that yes, on a prima facie scrutiny, this mark should never have been registered. But yet it is on the register, and today the person who has obtained wrongful registration of a mark comes and uses it as a shield, saying that no, you can't infringe my mark, although my registration may have been wrongful. So spend 3 years in litigation before the controller, and then come back and then we'll see. In which 3 years, my reputation is gone because today I will be injuncted, because my mark ultimately infringes a vital part of your mark. So what does one do? This matter went up before several courts and ultimately reached the Bombay High Court, where the Bombay High Court in a full bench decision ultimately said that no, if you really closely scrutinize the language of the statute, then you will find that it only gives prima facie validity to a registration. So, while you will be obliged to apply before the registrar or before the controller for cancellation of the registration, it is not as if when a court finds prima facie that mark should never have been registered at all in the first instance, the court will be powerless to do anything about it. It can still say that no, I will not give you an injunction because you were not entitled to registration in the first place. And in the meantime, of course, say that you go and apply for cancellation. There is also a provision in the Act which says that in such circumstances, there will be a stay of the suits. If I remember correctly, let me just try to see. I request you to please have a look at, I think it is section 124. Not 100% sure. But since this question has come up, let's look it up. Yes. Please have a look at 124. It says stay of proceedings where the validity of registration of the trademark is questioned. Very interesting section, and it has some nexus with what I was discussing so far. Where in any suit for infringement of a trademark, the defendant pleads that the registration of the plaintiff's mark is invalid, or the defendant raises a defense under clause E of subsection 2 of section 30, and the plaintiff pleads the invalidity of registration of the defendant's trademark, the court trying the suit hereinafter referred to as the court shall, if any proceedings for rectification of the register in relation to the plaintiff's or the defendant's trademark are pending before the registrar or the appellate board, stay the suit pending the final disposal of such proceeding. If no such proceedings are pending and the court is satisfied that the plea regarding the invalidity of the registration of the plaintiff's or the defendant's trademark is prima facie tenable, raise an issue regarding the same and adjourn the case for a period of 3 months from the date of the framing of the issue in order to enable the party concerned to apply to the appellate board for rectification of the register. And subsection 2 says, if the party concerned proves to the court that he has made any such application as is referred to in clause B, Roman 2 of subsection 1, within the time specified therein, or within such extended time as the court may for sufficient cause allow, the trial of the suit shall stand stayed until the final disposal of the rectification proceeding. If no such application as aforesaid has been made within the time so specified or within extended time as the court may allow, the issue as to the validity of registration of trademark concerned shall be deemed to have been abandoned, and the court shall proceed with the suit in regard to other issues. I will not read the rest of it. This is enough. So what it really considers is that you may, in the course of defending or prosecuting an infringement action, you may say that the other mark is not validly registered. The defendant then may say that the plaintiff is not entitled to injunction because the plaintiff's mark is not validly registered, which means you have obtained a registration, but the registration should not have been obtained in the first place. And the defendant may also raise a defense of saying that I also have a registered mark, because you find that there is provision for honest concurrent use and dual registration by 2 users of the same mark. In that case, the court will do what? The court will say, very well, I shall not decide this question. You have it decided by the registrar or by the appellate authority, but in the meantime, the suit will remain stayed. 3 months' time is given, you approach the controller. If you file an application, then the suit will remain stayed till the matter is decided by the controller or the registrar. If you don't make an application, then it will be deemed that you have given up your challenge to the registration and the suit will proceed. This is, of course, stay of the suit. But what happens to the injunction? Because you will find that in most intellectual property matters, it is the initial order of injunction or refusal to grant injunction that determines the whole suit. If today, for example, I find that my product is injuncted and I can't sell the product with a particular mark till the suit is heard and decided, which may take a few years, in that case, my entire goodwill and reputation in the business that I say that I have built up will ultimately be demolished. So therefore, the grant of injunction is a very, very, very important consideration in all such suits. And of course, the injunction will have to be weighed on these several considerations, which we will look into hereafter. Because ultimately, I think that is what we are really concerned with here. And so far as that is concerned, stay of suit, very well, the suit will stay. We stay. You get the matter decided before the controller. In the meantime, what happens? Can you say that the court says that yes, I am not the controller, I will not decide the issue of whether the mark will remain on the register or will not remain on the register, but I will grant an injunction saying that no, the mark is validly registered or not validly registered. There the Bombay High Court, which judgment I will take you through, has said that no, the court will have a right to prima facie form its own opinion. It's not a final opinion. It's only a prima facie opinion. But so far as that is concerned, on that opinion, the court may ultimately decide the case. The registration of the mark was not validly obtained, and so we will proceed to not pass an order of injunction. Now this consideration is a very important consideration because this is not unusual for a party to come and say that how could you obtain registration of this mark? For example, Krishna biscuits. Now Krishna biscuits, Krishna by itself is not capable of protection, but biscuits is also by itself not capable of protection. Krishna biscuits here. But if you only obtain registration of the word Krishna, what happens is you have label mark Krishna biscuits, where you say I also have a registration of a Krishna. You say how could you have that? Because I now come and say I will sell Krishna Hosea. You say you will not be allowed to do so because I have registration of the mark Krishna. The question is, court will say prima facie, how could you have obtained a registration of the mark Krishna? You could not. And this is where we come in. We stopped where we discussed about the provisions of section 124 and how it contemplates that when there is a challenge to a registration in the course of hearing of a trademark action, then the court can stay, or the court should stay, the suit initially for a period of 3 months with a direction to the party to take the challenge before the registrar or the controller, and then thereafter, depending on whether such a challenge has been brought before the registrar, the court will either stay the suit permanently till the completion of that adjudication, or will say that no, the challenge has been given up because no such application has been filed. And we'd also discussed in that context that the courts have held, of course that decision I will have to show you, the courts have held that no, the court can always, notwithstanding the fact that ultimately the challenge will be decided by the registrar, can prima facie decide on the question for the purpose of grant of an injunction. Following from there, now I request you to please have a look at section 12, because we were discussing section 11, which is the relative grounds for refusal of registration, when we veered off into this question, because that appeared to be at that moment relevant. You'll find section 12 provides for honest concurrent user. Now we are talking about use of the mark. When we talk about, normally when we talk about the Trademarks Act, we talk about it in its application in India in the first part, international in the second part. We'll not go there, but please see section 12. It says, in the case of honest concurrent use or of other special circumstances which in the opinion of the registrar make it proper so to do, he may permit the registration by more than one proprietor of the trademarks which are identical or similar, whether any such trademark is already registered or not, in respect of the same or similar goods or services, subject to such conditions and limitations, if any, as the registrar may think fit to impose. So there are special circumstances when you find that two users or two manufacturers or two producers have been using similar marks or identical marks over a period of time, and both have acquired some goodwill and some reputation, and it will be extremely unfair to stop one in preference to the other. Then registration of a identical or similar mark can also be granted. So this is a departure from section 11. Section 12 carves out an exception. Section 11 says in such cases you can't grant registration. Section 12 provides for an exception to the rule and says in special circumstances, or when you find that there is no dishonest intention to ultimately gather the reputation or the goodwill of a particular product, but there has been honest and concurrent use. Now we talk about honesty means that the adoption of the mark is not dishonest, and we talk about concurrent use, which means that both of them have started using the mark almost at the same time. In such circumstances and other special circumstances, there is an exception which is carved out to the provisions of section 11. So section 9, 11 and 12 really talk about what registrations will not be granted, what registrations may not be granted, and when an exception to the rule can be carved out. And this becomes relevant again because today, if a person says that I am an honest concurrent user and I also have a registration concurrently, then one registered proprietor will not be able to get an injunction against another registered proprietor, but may do so against the rest of the world. That is also a provision which I should show you. After that, may I request you to please have a look at section 17. Now this is a very, very important part. This section is the bone of a lot of controversy and we use it very often in the course of litigation. Yes.
So I have one question.
Yes, please.
So in case of section 12, concurrent use would be, even the timeline is looked into?
Yes.
Timeline of use?
Yes, because for example today, if a particular user has started using a mark 10 years ago, and another person says that, look, I have been using a similar mark, but I have no presence in the market. Then the question would be, are you a concurrent user? Then the question would be that, is there any evidence to show that you were using the mark concurrently for which you should not be stopped from using the mark? Again, it boils down to one simple question. Have you over a period of time acquired a goodwill or reputation which would be unfair to take away from you simply because someone has come forward and registered a mark later? What would happen in this case is that I find that someone has obtained a registration of a particular mark, but I have also been using the mark from around the same time. Then I apply for registration, saying that my mark should also be registered. Section 11 is taken as a defense, that no, how can you obtain a registration? I am already in the market with a registered mark. There, the person will have to come forward, satisfy the registrar that no, I am a concurrent user. See, I have advertisement 10 years back. I have sales, I have balance sheets, I have invoices, I have a market, I have distributor network. So therefore, I can satisfy the registrar that I am a concurrent user. And I have been doing so honestly, because otherwise, it would neither be concurrent nor be honest. If, for example, I say I have been using this mark 10 years ago for a past 10-year period, but I have nothing to show for it, and I come forward seeking registration saying that, look, I have been using the mark, and I come forward with a set of manufactured invoices, but I have no tax returns to show for the goods. Or I can come with a set of distributors who actually have no presence in the market. In that case, it would be not an honest use and not a concurrent use. In that case, it would be an attempt to ultimately cash in on my goodwill, where the honest concurrent registration under 12 will not be allowed. So, as I said, it has if you look at the scheme of the Act, the scheme of the Act has a natural progression. 9 says absolute ground for refusal of registration. 11 says relative grounds for refusal of registration. 12 says an exception to the rule, but only to the satisfaction, on the satisfaction of the registrar, that there exist circumstances for which a departure should be made. And these are important because ultimately, when a matter comes to court on these questions, the question of whether you're an honest concurrent user who has applied for registration will also become relevant. Then may I request you to have a look at, skip over to section 27. (27) says that no person shall be entitled to institute any proceeding or to recover damages for the infringement of an unregistered trademark. Nothing in this Act shall be deemed to affect rights of action against any person for passing of goods or services as the goods of another person or as services provided by another person or the remedies in respect thereof. Now let us understand what is the field of application. I'm so sorry. Let us once go back to section 17. I didn't read section 17. You asked me a question and I forgot. Section 17 is a very important section. Let's go back to section 17 once. I'm very sorry. Now this section ultimately says that you can't obtain registration of a part of a mark. The registration of the mark must be a registration of the whole mark. Let us read the section together. When a trademark consists of several matters, its registration shall confer on the proprietor exclusive use to the right of the trademark taken as a whole. Notwithstanding anything contained in subsection 1, when a trademark A contains any part which is not the subject matter of a separate application by the proprietor for registration as a trademark, or which is not separately registered by the proprietor as a trademark, or contains any matter which is common to the trade or is otherwise of a non-distinctive character, the registration thereof shall not confer any exclusive right in the matter of forming only a part of the whole of the trademark so registered. What does this mean? It means that if I have registration of gold flake, I don't have registration over gold. It means if I have registration of a gold flake, I don't have registration of a flake. And today, I can't seek protection over the word gold or protection of the word flake, but I can seek protection over the word gold flake taken together. Now, very often you'll find that when there's no word mark registration, it's only a label mark registration. It happens very often that there is no registration of a word, but a registration of a label. Now you say that, look, I am saying that you have copied a very distinctive part of the label. The court will then see as to whether the distinctive part is in the writing of the name, in the colorization of the product, in the stylized manner in which the logo is created. What is the most distinctive part? What is being sought to be catched off? Now, in the gold flake packet, gold is a very significant factor. I was arguing a case very recently. Gold flake is ITC, and my client was manufacturing gold stack. Now, the first question was the color of the packet. They were both golden packets. Now, why golden packets? You say if you have used a golden packet, then you're copying. You're attempting to pass off. But then, you see, if you look at the color of the harvested tobacco, it is gold. Golden in color. It's not gold, it's golden. And you'll find that there are many tobacco manufacturers which use this golden packet, because ultimately it has a connection with the trade. So you can't say that you can acquire a distinctive right over the golden color of the packet, because ultimately it represents, and the courts have held, that gold is a color, or golden is the color of the harvested tobacco, which is used for cigarettes. So it is not unusual to represent the packet color as gold. The next question is there any similarity within the words gold and stag? A gold stag and gold flake. Both start with the word gold. But today if you look at a person, he may be misled, said, give me gold flake, and someone gives you a packet of gold stag and you take it. Because the packet looks similar, then you look at the pricing of the product. ITC is priced at a much higher brand bracket. And then you can't mistake stag for flake. So these are the distinguishing features, but in my case, the court held, of course the matter is now in appeal, but the single judge held that no, there is no exclusivity in the word gold. But I find that overall you have tried to cash in on the gold flake mark, the packaging, the color combination, the manner of writing, etc., and granted an injunction. So while we succeeded on the question of whether gold can independently be the subject matter of protection, and the court said no, it can't be, then the next question was, if gold is not capable of independent isolated protection, then how can you give protection to gold flake for use of gold stack? And that is where judicial conscience comes in. I am sure all of you have experience in judiciary, all of you have often felt that no, the law says something, but my conscience says something else. So the court always molds the law as per its conscience. Because ultimately court is here to do justice. And the court's sense of justice is of course confined by the limits of the law. But then the law is subject matter of interpretation and subject matter of different application on different facts and circumstances of different cases. And here the court felt that yes, I can't say that you have exclusivity over the word gold. I can't say that gold stag is similar to gold flake. But then why did you come into the market with gold stag? There were so many other things you could have called it. Why did you have to come in the market with gold stag with a golden packet? And for cigarettes. where ITC has been manufacturing gold flake cigarettes for the last 80 years. So there the court's conscience is jolted. There the court feels that no, your adoption of the trademark is unfair. And if your adoption of the trademark is unfair, your attempt in such adoption is to ultimately influence customers into believing that your product has some association with the house of ITC, which is manufacturing gold flake cigarettes. And although it does not therefore strictly come within the limits of deceptive similarity, if you look at the definition, because if gold is not deceptive, then how can gold stack be deceptive? Because the identifying feature is gold. Take gold away from the name and what do you have? You have stag and you have flake. Are they similar? No. So the court takes into account an overall perspective of the thing. But this is where section 17 comes in. Section 17 says you can't give primacy to any particular part of a mark. If today you have a registered whole, you have to take gold flake as it is. You can't take away gold, take away flake, say flake has importance, gold has importance, and otherwise, when each of them by their own character is incapable of distinguishing the product. Now please come back and read section 17 once again. Notwithstanding, when a trademark consists of several matters, its registration shall confer on the proprietor exclusive right to use the trademark taken as a whole. And then, notwithstanding anything contained in subsection 1, when a trademark contains any part which is not the subject of a separate application by the proprietor for registration, gold is not the subject of a separate application for registration as a trademark, or where it is not separately registered by the proprietor as a trademark, and or it B contains any matter which is common to trade or otherwise is of non-distinctive character, the registration thereof shall not confer any exclusive right in the matter forming only a part of the whole of the trademark so registered. So he says you can't dissect a trademark, you can't break it up into pieces, and you can't say because I have a registration of the whole, I also have registration over its parts. And this becomes very important in the context of considering as to whether there is a deceptively similar mark in the market. And here you will find that very often, like in this case gold flake and gold stag, gold is constant. What is the suffix? In one case it is flake and in one case it is stag. The question is, to what extent does the suffix ultimately make the distinction or create the identity? So that is what the court has to see, and the court has to see it. At the first impression the court may feel that no, it is the same. On a closer scrutiny the court might feel that no. If you look at the entire body of jurisprudence on the subject, you'll find that the law has developed and made a distinction between these. These are the things that we look for. For example, if I find that there is a large number of cigarette manufacturers in the market who use gold as a suffix or a prefix. For example, you will all have heard of Marlboro Gold. That's also gold. But why is Marlboro not injuncted? Because Marlboro by itself is very significant. It identifies its cigarettes Marlboro, and gold in this case is laudatory. It says gold means it's a superior product. Like in Gillette, they use the word champions. The court said champion is a laudatory product, it is not capable of distinctiveness. So the idea of section 17 is to ultimately assert the fact that you can have a registration of a mark, but that will not give you a right over registration of its different parts, which are not independently registered. I will be taking you through one or two cases on this. Then please come to section 27. Section 27 is the only section in the statute which ultimately protects the right of the prior user. Because as I said, the Trademarks Act does not talk about the prior user or its rights. It is a common law principle which has been developed by the common law jurisprudence. Please read section 27 with me. No person shall be entitled to institute any proceeding to prevent or to recover damages for the infringement of an unregistered trademark. So if you don't have a registration of a trademark, under this statute you cannot claim infringement. The sine qua non for this is you must have a registered trademark. Then subsection 2, please read it. Nothing in this act It's a non-obstante provision. Nothing in this Act shall be deemed to affect rights of action against any person for passing off goods or services as the goods of another person, or as services provided by another person, or the remedies in respect thereof. So therefore this Act will not ultimately interdict a right of a person who comes and alleges passing off. Now, we will find very often that there are rolled up actions brought to court for both infringement and passing off. You will find that the plaintiff comes to court and say that, look, I have a registered mark and you have infringed my mark. In any event, I was in the market for a long time. You have come in much later. So you are trying to pass off your product as mine. And when this rolled up cause of action is brought, one part of the action receives scrutiny under the provisions of the Trademarks Act. The other part receives scrutiny under the common law jurisprudence. There the courts have said that no, ultimately if today I find that there is a prior user and there is a subsequent registered user, if the prior user is actually a prior user, he will be able to get an injunction against the subsequent registered user as well. And that common law right has received recognition in subsection 2 of section 27. It says, nothing in this Act shall be deemed to affect rights of action against any person for passing off goods or services as the goods of services of another person. Which says that this Act will not therefore limit the right of a person who comes and claims passing off. Although this section by itself is not very vocal or very assertive in its sense, ultimately the body of cases on the subject that has developed over the years is very, very clear. The Supreme Court is also very clear on the subject that no, the primary right will be that of a person who is the prior user. And he can claim passing off even against the subsequent registered user. Then please see, what is the right of a registered user? Here we are talking about the unregistered user has no right. Except he can claim the right of passing off if he is the prior user. 28 now says what are the rights that are available to a registered user. Rights conferred by registration. Subject to the other provisions of this Act, the registration of a trademark shall, now kindly mark the word, if valid. If valid, give to the registered proprietor of the trademark the exclusive right to the use of the trademark in relation to the goods or services in respect of which the trademark is registered, and to obtain relief in respect of infringement of the trademark in the manner provided by the Act. Let us read it a little slowly, let us break it up. It says, subject to the other provisions of the Act, the registration of a trademark shall, if valid. Now, why is this important? This is the section, or this is the provision, or this is the expression which the Bombay High Court has relied on to say that therefore the court has a duty to see prima facie if it is valid. The validity may be challenged before the registrar. But today, if you look at the rights conferred by registration, then the court is not powerless to say that prima facie, I find that the registration is not valid. So if valid, assume significance there. Then, thereafter if you see, it says that if valid, give to the registered proprietor of the trademark the exclusive right to use the trademark. Then please see, in relation to goods or services in respect of which the trademark is registered. So today, if I obtain registration in respect of chocolates for Kit Kat, then it is normally, except for the case of well-known trademarks, would be ultimately confined to the particular product for which the registration is obtained. It is not an all-encompassing registration which will cover every kind of product or every class of products, as we say in Trademarks Act. So the two important features are, it has to be a valid registration, and if it is a valid registration, it will grant exclusivity in respect of the goods or services for which the registration is obtained. Because when you apply for registration, you apply under different classes. And the different classes cover different goods. And amongst the different goods, you may also have particular goods for which you have applied. For example, although in tobacco, you'll find that both chewing tobacco and cigarettes come under the same class. They have held by the court not to be cognate goods. When we talk about cognate and agnate goods, why is this relevant? Because we are saying here that it gives right in respect of that product. Now, today therefore, the question is whether toothbrush and toothpaste will receive the protection of section 28. Courts have held that toothbrush and toothpaste are cognate. They are in the sense of the same product. So if I have a particular registration, let's say Colgate in respect of toothbrush, someone can't manufacture Colgate toothpaste or vice versa. Or Vajradanti in case of toothpaste, someone can't say, I'll suddenly start manufacturing Vajradanti toothbrush and say, get it. So these are ultimately cognate goods because they ultimately reflect on each other. They mirror each other. But again, the courts have also similarly held that in case of agnate goods, although under the same class, they will not receive similar protection. Chewing tobacco and cigarettes. So therefore, it becomes necessary when you look at section 28 to understand the expression in respect of relation to goods and services in respect to which trademark is registered, as also extending to cognate or agnate goods. Then please see subsection 2. The exclusive right to the use of trademark given under subsection 1 shall be subject to any conditions and limitations to which the registration is subject. Again, I use the example of the word gold flake. Today the gold flake word is registered, but there's a disclaimer in the registration saying there will be no exclusivity claimed over the word gold. Now when you have a disclaimer of this nature, then it falls within subsection 2 of section 28. So just to create clarity in the matter of what is the right that one can canvass in respect of a particular registered mark, you can come forward and say that look, gold flake is there, but there's a particular disclaimer over the word gold. And this is only a very narrow narrative, but this is where disclaimers become very important. So you will find that there are so many cases where the courts have held, no, you can't claim that this is an essential feature of your mark because there is a disclaimer over this. What happens very often is, again take the example of gold flake. I say that look, gold is the most prominent feature of my mark. Or for that matter, look at fair and handsome or fair and lovely. Fair is the most prominent feature of my mark. Fair is not independently capable of distinguishing anything. But you come and say that look, fair and handsome without fair would have no meaning. So if you take away fair, then you're really representing that one is the part of the other. The question then becomes a very interesting question. Can you then overcome section 17, which says you will have no exclusivity over a part of a mark? And can you in such circumstances when today the registration is granted to you with an accompanying disclaimer in the registration itself, you will claim no exclusivity over fair or over handsome or fair and beautiful, but you will claim registration over them together. Then the question is that to what extent are you entitled to receive protection? And I can tell you that this has received endless hours of argument before courts, because notwithstanding what the statute says, ultimately the court is always trying to see, is it an essential feature of the mark? When you have copied it, was the idea to actually trade on the goodwill and reputation of the product? So we are looking at the statute and understanding what are the perimeters that the statute has established. But again, when you look at every case and the facts and circumstances of every case, like you always do, ultimately you apply the law to the facts and circumstances of the case and you try to find out that was the adoption honest, was it dishonest? In the course of trying to ultimately use a particular trademark, are you actually cashing on the reputation of goodwill of a person who has built it up over the years or no? These questions come up for consideration constantly, and ultimately I'm sure that you will decide it on the basis of the law, but also using your ocular and hearing perceptions about how it sounds and how it looks. Then please have a look at subsection 3. Where two or more persons are registered proprietors of trademarks which are identical with or nearly resemble each other, the exclusive right to use any of those trademarks shall not, except so far as their respective rights are subject to any conditions or limitations entered on the register, be deemed to have been acquired by one of those persons as against the other of those persons merely by registration of the trademarks, but each of those persons has otherwise the same rights as against other persons not being registered user by way of permitted use, as he would have if he were the sole registered proprietor. What this essentially says that if you have two registrations, and we have spoken here about honest and concurrent user. In that case, against each other they will have no rights, but they can project and protect their rights against the rest of the world. So it is, you see, in a manner of speaking, you can see how one section flows into the other section and how the scheme of the act is built up to give protection, and how it also provides for limitations on these protections. Then, this is the section which we are always dealing with in court, section 29. Infringement of registered trademarks. A registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which is identical with or deceptively similar to the trademark in relation to goods or services in respect of which the trademark is registered, and in such manner as to render the use of the mark likely to be taken as used as a trademark. So this says again, it has to be identical or deceptively similar to the trademark, and it has to be in relation to goods or services in which the trademark is registered. So A, identity or similarity, and B, goods and services. Now subsection 2 is more clarificative in this regard, and subsection 3 talks about confusion. A registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which, because of A, its identity with the registered mark, and, please see, it's a conjunctive and similarity of the goods or services covered by such registered mark, or B, its similarity to the registered mark and the identity or similarity of the goods or services covered by such registered mark, or its identity with the registered trademark and the identity of the goods and services covered by such registered trademark is likely to cause confusion. So A, we have identical trademark, similar goods or services. B, we have similar trademarks, identical or similar goods and services. And C, we have identical trademark and identical goods and services. Now what it says is that in case, that is subsection 3, in any case falling under clause C of subsection 2, which is identical trademark and identical goods and services, the court shall presume that it is likely to cause confusion on the part of the party. So the presumption, a statutory presumption, flows in case of identical trademark and identical goods and services. There is no such statutory presumption in cases of A and B, 2A and 2B, where the court will have to ultimately decide on the facts and circumstances. But when today the court finds that there is identity in the trademark and in the goods and services, there will be a statutory presumption on which itself the court can proceed to grant an injunction. And then see, 4, a registered trademark is infringed by a person who, not being a registered proprietor or person using by way of permitted use, uses in the course of trade a mark which is identical with or similar to the registered mark, is used in relation to goods and services which are not similar to those for trademarks. Now, what is the departure between 4 and 3 or 4 and 2? In 2 subsection A and subsection B you have seen, it says the mark has to be identical, the goods have to be similar. Mark has to be similar, goods have to be identical. C is mark identical, goods identical. 4 makes a departure. Please read 4 a little carefully. A registered trademark is infringed by a person who, not being a registered proprietor or person using by way of permitted use, uses in the course of trade a mark which is A, identical with or similar to the registered trademark. So first criteria is it has to be identical or similar to the registered trademark, and B, is used in relation to goods or services which are not similar to those for which the mark is registered. So trademark similar or identical, but the goods are not similar. This is departure. Why this departure? Please see, this is the reason for the departure. C, and the registration. So 4A is succeeded by and, which is conjunctive, that connects 4A to 4B, and 4B is also connected to 4C with an and. It's also conjunctive, and says, and the registered trademark has a reputation in India, and the use of the mark without due cause takes unfair of or is detrimental to the distinctive character or repute of the registered trademark, which means that when the mark has become so well known that you use this mark, even if it is in respect of unfamiliar or not similar goods and services, then you will be actually giving the impression that it is from the same source, same house, same stable. So there, again, section 29(4) carves out exception. This would apply in case of well-known trademarks. Yet there is nothing in the statute which says what are the defining features of a well-known trademark. When do we call a trademark a well-known trademark? That again is a matter of judicial perception. The court will have to say, for how long is this mark in use? How well is it known to the general public? Does it transcend the border of the particular product for which it is used? Is it something that everyone knows by name in the segment in which it is used and then transcends the boundaries of those segments? So the courts have held in certain cases that I hold that this is a well-known trademark, this is not. But there is nothing in the statute which defines as to what are the guiding features of what a well-known trademark will be. Here the argument against us is gold flake is a well-known trademark, so you can't use it. But then the court said, no, I will not go by the factor of gold, well-known trademark. I will say that gold is not capable of defining it, but I find that there is an attempt to dishonestly ultimately use this mark. So 29 is a very important factor, and the distinction is 29 2A, B, C is distinguished by 29(4). Also see 29(5). A registered trademark is infringed by a person if he uses such registered trademark. Now how is it? As a trade name. Now you have a registration over gold flake. I start using gold flake enterprises. That is also infringement. A registered trademark is infringed by a person if he uses such registered trademark as his trade name or part of his trade name or name of his business concern or part of the same or part of the name of his business concern, dealing in goods or services in respect of which the trademark is registered. So again here, I cannot use it as my name if I am dealing with the same class of goods and services. I might not be using that feature to identify my goods or services. But Gold Flake Enterprises, then dealing with a brand of cigarettes which is called Charminar. I can't do that. That is prohibited. Then it says, for the purpose of this section, a person uses a registered mark if, in particular, he affixes it to goods or the packaging thereof, offers or exposes goods for sale, puts them on the market, or stocks them for the purposes under the registered trademark, or offers or supplies services under the registered trademark, C. imports or exports goods under the mark, uses the registered trademark on business papers or an advertising. We can understand all of this, 6, but what is important is, please see 6C. Imports or exports goods under the mark. Now, 6 is a very interesting feature of the Trademarks Act again, 6C. There are many cases where, let us say, a product is manufactured in China. The product is registered in China in favor of the Chinese manufacturer. An Indian importer imports that product into India. And he registers that mark as his mark. And then he says that anyone else who is importing the same product from China from the same source cannot use the mark in India. The question then is he infringing or not? This is something that is known as the doctrine of reverse passing off. Of course, reverse passing off cases are there, but few and far between. It is mostly covered by English judgments in the field, English and American judgments in the field. But this is known as reverse passing off. So ultimately, if I am buying from the same manufacturer in China, and he has a registration of the mark for the product which I am buying in China, and I come and obtain a registration of that product in India, can I stop another person who is buying the same product from the same manufacturer in China from selling it under the same name? There the doctrine of reverse passing off says you cannot. But reverse passing off is something that I think is is of very rare application in the field, so we will not discuss it further. Particularly, most of the body of law on the subject is foreign law. There are one or two Indian judgments, but that is what it is. Now thereafter, just going through, I will not trouble you with the entire act, just 3 or 4 more sections. And after that, please come to section 31. Now this is also something that weighed with the Bombay High Court, the full bench of the Bombay High Court, when it concluded that no, we can look into whether there is a prima facie validity of a trademark for the purpose of granting injunction or refusing to grant injunction. Please see registration to be prima facie evidence of validity. What is it? Registration is not absolute evidence of validity. It's only prima facie evidence of validity. It says, in all legal proceedings relating to trademark registered under this Act, including application under section 57. Why 57? 57 is the ground for cancellation. In all legal proceedings relating to trademark registered under this Act, including application under 57, the original registration of the trademark and of all subsequent assignments and transmissions of the trademark shall be prima facie evidence of the validity thereof. So if it is only prima facie evidence of validity, in that case the question is, why can't the court look into it for the purpose of deciding as to whether even when a mark is on the register, if I find that it does not subscribe to the notions of section 9 or section 11, it was incapable of being registered in the first place, it could not have been or should not have been registered, why can't I look into that and then say that no, even pending inquiry before the registrar, I shall not give an injunction because I don't think that the registration is valid. Because the expression is the statute is, it's only prima facie evidence of validity, not absolute evidence. Thereafter, please have a look at section 33. This is what I discussed earlier, the effect of acquiescence. Where the proprietor of an earlier trademark has acquiesced for a continuous period of 5 years in the use of a registered trademark, being aware of that use, he shall no longer be entitled on the basis of that earlier trademark to apply for a declaration that the registration of the later trademark is invalid, or to oppose the use of the later trademark in relation to goods or services in relation to which it has been used, unless the registration of the later trademark was not applied in good faith. So what this essentially says, that if you have stood by and allowed a mark to be used for a continuous period of 5 years, and if today you then have to come and try to seek an injunction restraining the use of that mark, then you shall not be allowed to do so, because the presumption of law is that in 5 years you have yourself developed some goodwill and reputation in the use of the mark. For example, if you draw a parallel with this to the law of adverse possession, if I know that you are occupying my land, which is hostile to my interest, and I do nothing about it for a period of 12 years, Article 65-66 of the Limitation Act comes in and says that you cannot assert a right over this any longer. Similarly, the limitation period here, which is statutorily engrafted, is a period of 5 years. So if I have allowed you to use a particular mark, which I claim is my own, whether as a prior user or a registered proprietor, and you develop an independent reputation in the mark, in that case I will not be allowed to come forward and say after that period of 5 years that no, you cannot use it. It is by the doctrine of acquiescence that if you have allowed someone to do something knowingly, you cannot resile from that. This is also used in the field of administrative law, but we will not go in there. Then please have a look at section 34 once. I'm sorry, I made a mistake when I said that the only reference to prior user was in section 28. It's also in section 34. Saving for vested rights. Nothing in this Act shall entitle the proprietor or a registered user of the registered trademark to interfere with or restrain the use by any person of a trademark identical with or nearly resembling it in relation to goods or services, in relation to which that person or a predecessor in title of his has continuously used that trademark from a date prior. So this says that ultimately a registered proprietor will not be able to stop a prior user from using the mark. And here, please also have a look at the subsequent subparagraphs. Title has continuously used that trademark from a date prior, A, prior to what? Prior to the use of the first mentioned trademark in relation to those goods or services by the proprietor or a predecessor in title of his, that is the proprietor of the registered mark or a predecessor, or B, to the date of registration of the first mentioned trademark in respect of those goods or services in the name of the proprietor of a predecessor in title. So that is a saving, which says that if you're a prior user and your use is prior to the registration of the trademark, in that case the prior user will have a right which is a greater or a better right. And then 35, it says, nothing in this act shall entitle the proprietor or registered user of a registered trademark to interfere with any bona fide use by a person of his own name or that of his place of business or of the name or the name of place of business of any of his predecessors in business, or the use by any name of any bona fide description of character or quality of your goods and services. This section is something again which provides a limitation to the rights of a registered proprietor. It says, for example, if I am carrying on business with my own family name or name of the place from which I hail, let us say that Cox Bazar Enterprises, name of a place from which I hail, or Muhammad Musa and Sons, name of the person. So there is no federal restriction, although there ultimately might be some kind of similarity, because the presumption again is that you are not unfairly adopting a trademark. It is actually a part of your name, it's actually part of the business place from where you hail. This is more or less the limits. Just two more sections I want to show you before I close the statute for the time being. Please have a look at sections 47 and 57 once. This is what we have been discussing in the passing. A registered trademark may be taken of the register in respect of the goods and services in respect of which it is registered, on application made in the prescribed manner to the registrar or the appellate board by any person aggrieved, on the ground either that the trademark was registered without any bona fide intention on the part of the applicant for registration that it should be used in relation to those goods or services by him, or in a case to which the provisions of section 46 apply, by the company concerned or the registered user, as the case may be, and that there has in fact been no bona fide use of the trademark in relation to those goods or services by any proprietor thereof for the time being up to a date of 3 months before the date of application, or that up to the date of 3 months before the date of application a continuous period of 5 years from the date on which trademark is actually entered in the register or no longer has elapsed, during which the trademark was registered and during which there was no bona fide use thereof. Let us stop here. The rest of it is not important. Thus, what this says is that you can't traffic in trademarks, or you can't have ghost marks. The idea is to protect bona fide use of marks. You can't today apply for registration of an entire bouquet of marks to just prevent someone else from using those marks without actually putting these marks to use. The idea is not to allow anyone to traffic in marks. So this is the object of section 47, and this says that provided the qualifications of section 47 are met, 3 months before the date of application, no use, 5 years for a continuous period, no use, then you should be allowed to apply for removal of the mark from the register, so that it does not continue to ultimately prejudice a person who is going to bona fide use the marks. And the courts have held that we will not allow trafficking in trademarks, or we will not allow ghost marks to remain in the register. So that is on the ground of non-use. 47 talks about rectification of the register on the ground of non-use of the mark. 57, however, on the other hand, is different. That talks about the power of cancellation when a mark has not been validly registered, or it has been registered in contravention of the principles of section 9, 11, etc. 57 says, on application made in the prescribed manner to the appellate board or to the registrar by any person aggrieved, the tribunal may make such order as it may think fit for cancelling or varying the registration of a trademark on the ground of any contravention or failure to observe a condition entered on the register in relation thereto. It says any person aggrieved by the absence or omission from the register of any entry or by an entry made in the register without sufficient cause. Kindly mark the words or by an entry made in the register without sufficient cause, or by any entry wrongly remaining on the register, or by any error or defect in the entry in the register may apply in the prescribed manner to the appellate board or to the registrar, and the tribunal may make such order for making, expunging or varying the entry. I am not reading the entire section or the entire subsections because I am trying to convey what is the whole purpose. The purpose is if it is wrongly in the register, either because of any contravention of the condition of registration or any contravention of the provision of the statute which did not permit its registration in the first place, you can apply for its removal. Now, there are of course many other sections in that, but I don't want to trouble you with that, because to my understanding, these are the principal sections which ultimately confront the courts in their application of the Trademarks Act and the laws of infringement. The question is that how have the courts progressed in the development of these laws? Now, before I go there, I will just like to very briefly show you what is the parallel of the Trademarks Act with the Copyright Act. I'll just take a very short time over this. Similar rights are afforded to a copyright registration. Kindly just have a look at first at section 2, the interpretation section in the Copyright Act. Please see how the word adaptation has been defined. I will not similarly traverse through the provisions of the Copyright Act because I don't think we really have time for that, but please see what is the essential distinction between a Copyright Act and a Trademarks Act. Please see the meaning of the word adaptation. In this act, unless the context otherwise required, adaptation means in relation to a dramatic work, the conversion of the work into a non-dramatic work, in relation to a literary work or an artistic work, the conversion of work into a dramatic work by way of performance in public or otherwise, in relation to a literary or dramatic work, any abridgment of the work or any version of the work in which the story or action is conveyed wholly or mainly by means of pictures in the form of suitable for a reproduction in a book or a newspaper magazine. Then in relation to any musical work, any arrangement or transcript of the work, in relation to any use of such work involving its rearrangement or alteration, etc. So when we are talking about adapting a copyright, of course it has to be a permitted adaptation. But ultimately the Copyright Act applies to different fields, and ultimately it applies to different fields in the genre of dramatic works, artistic works, musical works, etc. And then please have a look at section 13, I'm sorry. Works in which copyright subsists. These are the kind of works that are capable of receiving copyright protection. Subject to the provision of this section and the other provisions of this Act, copyright shall subsist throughout India in the following classes of works, that is to say, original literary, dramatic, musical and artistic works, cinematograph films, sound recording. Copyright shall not subsist in any work unless work specified in subsection 1 other than a work to which the provisions of section 40 and 41 apply. Then if you see meaning of copyright, which is section 14, for the purpose of this act, copyright means the exclusive right subject to the provisions of this act to do or to authorize the doing of any of the following acts in respect of a work or any substantial part thereof, in the case of literary, dramatic or musical work not being a computer program. What can you permit? What are you permitted to? To reproduce the work in any material form, including the storing of it in any medium by electronic means, to issue copies of the work to the public, not being copies already in circulation, to perform the work in public or communicate it to public, to make any cinematograph, film or sound recording in respect of the work, to make any translation of the work, to make any adaptation of the work, to do in relation to a translation or an adaptation of the work, any of the acts qualified in relation to the works. So first thing is in respect of literary, dramatic or musical work. These are the things that you can do to allow the use of the work, and you can assign your right to these uses. Then please see the next part of it, in relation to a computer program. That is also subject matter to copyright protection. In case of a computer program, to do any of the acts specified in clause A, that is whatever we have said, or to sell or to give commercial rental or offer to sell for any commercial rental any copy of copyright program, computer program, provided that such commercial rental does not apply in respect of computer programs where the program itself is not the essential object. So A, we find it applies to literary, dramatic, musical work, B to computer programs, C to artistic work. Now artistic work in its present avatar is not only paintings, but it is three-dimensional artistry also, and that is what's protected. It says to reproduce the work in any material form, including storing of it in any medium by electronic or other means, or depiction in 3 dimensions of a 2-dimensional work, or depiction in 2 dimensions of a 3-dimensional work. And then D, you have the rights, similar rights in respect of cinematograph films, so forth. So these are the different aspects of copyright protection. Section 17 says who shall be the first owner of a copyright, and then by the virtue of assignment there can be assignment of copyright, which is section 18. So section 17 says who is the first owner. The artist is the first owner, the composer is the first owner, the lyricist is the first owner. And it says section 18 provides for assignment of the right. It says the owner of the copyright, that is the first owner, in an existing work, or the prospective owner of the copyright in a future work, may assign to any person the copyright either wholly or partially, and either generally or subject to limitations. So right of assignment is there. The terms of copyright, etc., you'll find from chapter 5, which is section 22. I will not take you beyond this. It says that normally the term of copyright will be 60 years from the date of death of a person, or it will be, what will be the term in case of a pseudonymous or anonymous mark, copyright work. Section 22 says, except as otherwise hereinafter provided, copyright shall subsist in any literary, dramatic, musical or artistic work published within the lifetime of the author until 60 years from the beginning of the calendar year next following the year in which the author dies. So copyright over Tagore's works survived for a period of 60 years from the date of his death. And then 23, in case of literary pseudonymous works, in case of literary, dramatic, musical or artistic work other than a photograph, which is published anonymously or pseudonymously, copyright shall subsist until 60 years from the beginning of the calendar year next following the year in which the work is first published. So one is 60 years from the date of death, and 2 is 60 years from the date of his first publication. What is publication has received a lot of attention in the Designs Act, to which I shall very briefly refer. Now, I don't want to take you through much more of the Copyrights Act, because essentially the Copyrights Act offers the same kind of protection that is available under the Trademark Act, except it extends to works that are not simplicity trademarks. Artistic works, musical works, compositions, photographs, pictures, paintings, cinematographs, etc. Now, so far as this is concerned, please let us now come back and discuss some of the facets as to how the judiciary has proceeded to amplify on these subjects. I'm sorry, I should have given you a list of the cases to which I would have referred, but I have not done that, so kindly forgive me. I shall try to read out from portions. You can make a noting of the citations. Now the first line of cases, there of course, I'm just giving you sample cases because the authorities in the field are now several, and the high courts have been furiously turning out judgments on these aspects, sometimes conflicting with each other. But even the Supreme Court does that, so what is the wrong? Now, so far as class is concerned, as I said, you have seen in the course of our discussions that normally the protection that is available is to a trademark which is identical or similar and in respect of similar class of goods. Now this matter had come up for consideration before the Supreme Court in the case of, in the case of Wazir Sultan Tobacco. The mark in question was Charminar. You are all familiar that Charminar was a very, very popular brand of cigarettes once upon a time. It was the only cigarette without filter which caused the maximum damage to people, but it was one of the most popular. It was cheapest and the most popular. Now, this is Vishnu Das Trading. Don't write down the name, it will spend unnecessary time. The citation of the case that I am referring to is 1997, Volume 4, Supreme Court Cases 201. Now this is a case which talks about classification of goods and services and what we've been discussing, the application of the trademarks to classes of goods and services. And here again the question of cognate agnate comes in. So I'll just read 3 paragraphs. You can make a note of the paragraphs 47 to 49. I'll just read these 3 paragraphs. The respondent company got registration of its brand name Charminar under the broad classification manufactured tobacco. So long such registration remains operative, the respondent company is entitled to claim exclusive use of the said brand in respect of articles made of tobacco coming under the said broad classification manufactured tobacco. Precisely for the said reason, when the appellant made the application for registration of Qam and Zarda under the brand name Charminar, such prayer for registration was not allowed. The appellant therefore made application for rectification of the registration made in favour of the respondent company so that the said registration is limited only in respect of the articles being manufactured and marketed by the respondent company, namely cigarettes. In our view, if a trader or manufacturer actually trades in or manufactures only one or some of the articles coming under a broad classification, and such trader or manufacturer has no bona fide intention to trade in or manufacture other goods or articles which also fall under the said broad classification, such trader or manufacturer should not be permitted to enjoy monopoly in respect of all the articles which may come under such broad classification, and by that process preclude the other traders or manufacturers from getting registration of separate and distinct goods which may also be grouped under the broad classification. If registration has been given generally in respect of all the articles coming under the broad classification, and if it is established that the trader or manufacturer who got such registration had not intended to use any other article except the articles being used by such trader or manufacturer, the registration of such trader is liable to be rectified by limiting the ambit of registration and confining such registration to the specific article or articles which really concern the trader or manufacturer enjoying the registration made in his favour. In our view, if rectification in such circumstances is not allowed, the trader or manufacturer by virtue of earlier registration will be permitted to enjoy the mischief of trafficking in trademark. Looking to the scheme of the registration of trademark as envisaged in the Trademarks Act and the rules framed thereunder, it appears to us that registration of a trademark cannot be held to be absolute, perpetual and invariable under all circumstances. Section 12 of the Trademarks Act, here we are talking about the 56 Act of course, of the Trademarks Act prohibits registration of identical or deceptively similar trademarks in respect of goods and description of goods which is identical or deceptively similar to the trademark already registered. Currently it is section 28 and 29. For prohibiting registration under section 12(1), goods in respect of which subsequent registration is sought for must be in respect of goods or description of goods being same or similar and covered by earlier registration, and 2, trademark claim for such goods must be same or deceptively similar to the trademark already registered. It may be noted here that under subsection 3 of section 12 of the Trademarks Act, in an appropriate case of honest concurrent use and or other special circumstances, same and deceptively similar trademarks may be permitted to another by registrar, subject to such conditions as may deem just and proper to the registrar. It is also to be noted that the expression goods and description of goods appearing in section 12(1) of the Trademarks Act indicate that registration may be made in respect of one or more goods or of all goods conforming a general description. The Trademarks Act has noted distinction between description of goods forming a genus and separate distinctly identifiable goods under the genus in various other sections, example goods of same description in section 46, etc. The class mentioned in the 4th schedule may subsume or comprise a number of goods or articles which are separately identifiable and vendable and which are not goods of the same description as commonly understood in a class or in common parlance. Manufactured tobacco is a class mentioned in class 34 of the 4th schedule of the rules, but within the said class there are a number of distinctly identifiable goods which are marketed separately and also used differently. In our view, it is not only permissible, but it will be only just and proper to register one or more articles under a class or genus, if in reality registration only in respect of such articles is intended, by specifically mentioning the names of such articles and by indicating the class under which such article or articles are to be comprised. It is therefore permissible to register only cigarette or some other specific products made of manufactured tobacco, as mentioned in class 34 of the 4th schedule of the rules. In our view, the contention of Mr. Vaidyanathan that in view of change in the language of section 8 of the Trademarks Act as compared to section 5 of the Trademarks Act of 1940, registration of trademark is to be made only in respect of class or genus and not in respect of articles of different species under the genus, is based on incorrect appreciation of section 8. Since such registration initially had not been done, the rectification of the registration by limiting or confining the registration of trademark of the respondent company to particular goods, namely cigarettes, in the facts and circumstances of the case, cannot be held illegal or unjustified. The reason why I have chosen this case is because here the distinction is that there was a registration in respect of manufactured tobacco. Now, manufactured tobacco is a lot of things. It is gutka, it is chewing tobacco, it is cigarettes, it is snuff. And so far as this is concerned, this is not identified with cigarettes. But today, if you have registration over the class, then you are in fact trafficking over the mark, which would ultimately be available to others in respect of other class of the same product. So, while there can be Charminar cigarettes, there can also be Charminar Khaini or Charminar Zarda. So that is what the Supreme Court says. I am not particularly convinced about this argument personally. But yes, you can't allow a person to ultimately register, because here the question of cognate agnate would come. The Supreme Court did not consider the question of what is cognate and what is agnate really in this sense. Because if you look into the class of products as cognate and agnate products, then of course the question would be that whether Khaini or Zarda, which is also manufactured tobacco, is a part of the cognate class of goods with cigarettes. But that is apparently something that did not attract the Supreme Court's attention at that point of time. What is however important is the Supreme Court recognizes the fact that you cannot simply sit by obtaining registration in a class per se, ultimately say that I will have a right over all the goods comprised in that class, particularly with no intention of ever manufacturing those goods. And that would also in turn attract the provisions of section 47, which is the ground for cancellation of the mark on the ground of non-use. Now, I am using the mark for tobacco. I am using it in cigarettes. Can I say that the mark will be cancellation for non-use in respect of other classes of manufactured tobacco like Khaini or Zarda or chewing tobacco? That would be a question which would fall for consideration. But yes, if there is if the class of goods are agnate, if there is no connection, as courts have from time to time also held, in that case one can apply for cancellation of registration or rectifying the register to provide that this registration will ultimately be confined only in respect of cigarettes and nothing else. Now, so far as this is concerned, one interesting aside is that, I'll go to that separately, I don't think I should club this up together. Now here, so far as this is concerned, like toothpaste and toothbrush have been held to be cognate goods. Chewing tobacco and cigarettes, in this case, has ostensibly been held by the Supreme Court to be agnate, and so capable of separate challenge. Now, when I talked about publici juris, of course, we talked about Xerox and Hawaii chappals. But there is one decision which is also quite significant because it ultimately applies to a limitation in the use of registered trademarks. For this, I would request you to please make a note of 2015, volume 16 Supreme Court cases, page 795. I am relying on three paragraphs, paragraphs 20 to 23. Or 19 to 23, can I just make a note. This talks about the limitation when the mark is really publici juris, that is, it's available to all, without limitation. Here the word in question was Ramayan. The question was whether Ramayan could be a trademark. The word Ramayan represents the title of a book written by Maharshi Valmiki and is considered to be a religious book of the Hindus in our country. Thus, using exclusive name of the book Ramayan for getting it registered as a trademark for any commodity could not be permissible under the Act. If any other word is added as a suffix or prefix to the word Ramayan, and the alphabets or design or length of the words are same as of the words Ramayan, then the word Ramayan may lose its significance as a religious book, and it may be considered for registration as a trademark. However, so he said you can do it with a suffix or a prefix, but not Ramayan per se. However, in the present case, we find that the appellant had applied for registration of the word Ramayan as a trademark. We also find in the photographs after the word Om apostrophe S to the word Ramayan at the top, and in between Oms and Ramayan the sentence, 3 top class aromatic fragrance. So this was interspersed between the words. Om, 3 top class aromatic fragrance, and then Ramayan is also written. Thus, it is not a case that the appellant is seeking the registration of the word Om's Ramayan as a trademark. Further, from the photographs, we find that the photographs of Lord Rama, Sita and Lakshman are also shown in the label, which is a clear indication that the appellant is taking advantage of the gods and goddesses, which is otherwise not permitted. In National Bell Company, this court has held that the distinctiveness of a trademark in relation to the goods of a registered proprietor of such trademark may be lost in a variety of ways. Example, by the goods not being capable of being distinguished as the goods of such proprietor, or by extensive piracy, so that the marks become publici juris. Extensive piracy would be the word Hawaii, Xerox, etc. The principle underlying clause C of section 32 is that the property in a trademark exists so long as it continues to be distinctive of the goods of the registered proprietor in the eyes of the public or a section of the public. If the proprietor is not in a position to use the mark to distinguish his goods from those of others, or has abandoned it, or the mark has become so common in the market that it has ceased to connect him with his goods, there would hardly be any justification in retaining it on the register. It has also come on record that the word Ramayan is being used as a mark for similar products by more than 20 traders in Patna and in different parts of the country, and therefore it has become publici juris and common to the trade. Conclusion is, there are many holy and religious books like Quran, Bible, Guru Granth Sahib, Ramayana, etc. to name a few. The answer to the question as to whether any person can claim the name of a holy or a religious book as a trademark for his goods or services marketed by him is clearly no. Moreover, the appellant has not been able to establish that the word Ramayana, for which he has applied the trademark, had acquired a reputation of user in the market, inasmuch as we find that there are more than 20 traders in the city using the word Ramayana as a part of the similar products also in different parts of the country. On perusal of the artistic work said to have been created, there is no doubt that both the marks are identical in design, color scheme and reproduction of photographs is as such a manner that an ordinary buyer would reasonably come to a mistaken conclusion that the article covered by one brand can be the article covered by other. Both the parties have claimed to be manufacturing units engaged in certain goods. Then it says further, the respondent herein has claimed that he had been in the business since 1980. He had developed and published artistic work in 1986 and has also been using the mark as a trademark and claiming use since 1986, whereas the appellant herein claimed use of the trademark since 1987. However, by filing an application to the authority concerned, the appellant has claimed the use since 1981. Further, in various pleadings and the title suits filed by the respondent, appellant herein has admitted the use and publication of the artistic mark of the respondent from the date of claim of the first use by the appellant, that is 1987. From these facts, it is clear that the respondent herein was using the artistic mark earlier in point of time to that of the appellant. In view of the foregoing discussion, we do not find any irregularity in the order. Now, this is very interesting. Why? Because you find what is here. First of all, use of the word Ramayana. He says Ramayana has so commonly been used because at least 20 persons are using it in respect of the same trade in the same state. Secondly, it is something over which you cannot really claim exclusivity because it is the name of a holy text or of a name of a god, Hindu god. But it says, therefore you can't claim any registration or rights flowing from registration. What does the court then do? There are two conflicting users, both using Ramayana, both using it in a manner which is confusing. The court says the prior user will have the right to use the mark. So you step away from the statute, you get into the domain of common law, and you say that no, since both are using it and we cannot allow the public to be deceived or to be confused, we will allow the principle of prior user to take effect here and allow the first user to use. So three things are established by this judgment. A, names of gods, goddesses, holy books cannot be used as a trademark. B, if these assume the character of a public property by continuous use by several users, it cannot have any right, and even if there was a right, it has been extinguished by the appropriation of the mark by the public as in general. And C, when in such circumstances you cannot ultimately vest in one person a trademark right under the Trademarks Act, thereby giving him protection from infringement. If he is entitled to such protection by reason of prior use under the common law, then he is entitled to that protection. So this is how the judiciary has applied itself to develop the law in these fields. And it has ultimately taken a very common sense view of things at times, because ultimately what are we looking at? We are looking at commercial law. We are looking at how people actually carry on trade and business. What is their purpose of using a trademark? Is the purpose genuine? Is the purpose mana fide? Now, one of the most common cases when one looks at what are the tests to be applied to determine as to whether a trademark is in fact an attempt to ultimately cash in on the goodwill and reputation of another mark is the case of Kaviraj Pandit Durgadat Sharma. It is an older case. It is reported in All India Reporter 1965, Supreme Court 980. And this is a case which has ultimately been referred to in a large number of other decisions also. I'll just read one paragraph which ultimately is a paragraph which has been quoted by the Supreme Court in many cases. But before that, what was in issue was, I'll just read one paragraph here first. The original suit, as stated earlier, for a perpetual injunction against the appellant for using the word Navaratna, and the cause of action for that suit was stated to be that the plaintiff, being proprietor of the two registered trademarks, Navaratna and Navaratna Pharmaceutical Laboratories, had an exclusive right to use of those marks for his medicinal preparations, and that the said right was infringed by the defendant advertising its goods under the name Navaratna Kalpa. So Navaratna was the registered mark, and Navaratna Pharmaceutical Laboratories was also registered, and here the defendant was using Navaratna Kalpa, and he was also trading as Navaratna Kalpa Pharmacy. Now, With that, paragraph 28 is the discussion in the judgment. The other ground of objection that the findings are inconsistent really proceeds on an error in appreciating the basic differences between the causes of action and the right to relief in suits for passing off and for infringement of a registered trademark, and in equating the essentials of a passing of action with those in respect of an action complaining of an infringement of a registered trademark. So the distinction between infringement and passing off is also being discussed. We have already pointed out that the suit by the respondent complained both of an invasion of a statutory right under section 21 in respect of a registered mark and also of a passing off by the use of the same mark. The finding in favour of the appellant, to which the learned counsel drew our attention, was based upon dissimilarity of the packing in which the goods of the two parties were vended. So the argument was, look, the packing is dissimilar, so it can't be a result of passing off. The finding in favour of the appellant, to which the learned counsel drew our attention, was based upon dissimilarity of the packing in which the goods of the two parties were vended. The difference in the physical appearance of the two packets by reason of the variation in the colour and other features and their general get-up, together with the circumstances that the name and address of the manufacturer of the appellant was prominently displayed on the packets, and these features were all set out for negativing the respondent's claim that the appellant had passed off his goods as those of the respondent. These matters, which are the essence of the cause of action for relief on the ground of passing off, play but a limited role in an action for infringement of a registered trademark by the registered proprietor who has a statutory right to that mark and who has a statutory remedy for the event of the use by another of that mark or a colourable imitation thereof. While an action for passing off is a common law remedy, being in substance an action for deceit, that is, a passing off by a person of his own goods as those of another, that is not the gist of an action for infringement. The action for infringement is a statutory remedy conferred on the respective proprietor of a registered trademark for the vindication of the exclusive right to use the trademark in relation to those goods. The use by the defendant of the trademark of the plaintiff is not essential in an action for passing off, but is the sine qua non in the case of an action for infringement. No doubt, where the evidence in respect of passing off consists merely of the colourable use of a registered trademark, the essential features of both the actions might coincide in the sense that what would be a colourable imitation of a trademark in a passing of action would also be such in an action for infringement of the said trademark. But there the correspondence between the two ceases. In an action for infringement, the plaintiff must, no doubt, make out that the use of the defendant's mark is likely to deceive, but where the similarity between the plaintiff's and the defendant's mark is so close, either visually, phonetically or otherwise, and the court reaches the conclusion that there is an imitation, no further evidence is required to establish that the plaintiff's rights are violated. Expressed in another way, if the essential features of the trademark of the plaintiff have been adopted by the defendant, the fact that get-up, packing and other writing of the marks on the goods or on the packets in which he offers the goods for sale show marked differences or indicate clearly a trade origin different from that of the registered proprietor of the mark would be immaterial. Whereas in case of passing off, the defendant may escape liability if he can show that the added matter is sufficient to distinguish his goods from those of the plaintiff. Pausing here for a moment, what is being said here is that in an action for infringement, if you find that there is similarity of the mark and the product, that's the end of it. But in an action for passing off, it is possible to say that no, there is no statutory protection available, and I can ultimately say that no, look, I have distinguished the product by the use of a suffix or a prefix. But what is important is that the court first looks at whether it is an imitation. And for that the court looks at the phonetic similarity, the visual similarity, and then forms the conclusion. Of course, then it applies the different limitations, and the distinction here that has been made between a passing of action and an action for infringement is essentially this. In infringement, you compare mark to mark. Is there a copy? In a passing off, you say whether there's a possibility of creating confusion because of the added matter. Stag, flake, gold remaining constant. So these are the tests. So the first test, which a court always says, and this is the first impression of the court that always becomes important, the court immediately calls for the two goods. Normally when we talk about a passing of action or an infringement action, let us see the two products. And the products are brought before the court, and the court compares the products, apples for apples. These are not apples and oranges. And then the court is satisfied that this is ultimately something that requires protection. In infringement, the question is that you have a registered trademark which entitles to a statutory protection. Here if you compare, then you apply the test of section 29. Similar product, similar mark. Identical product, identical mark. Similar product, identical product, similar mark, and vice versa. Those tests. And of course, if there is a situation which would call for application of subsection 4 of section 29, that you can also apply it in case of dissimilar products, because the mark is well known, then that is also available. Otherwise, in a scrutiny of this nature, the court would normally see what? Yes, I find that the marks are similar, but the goods are different. So no protection. But yes, I find that the marks are similar, the goods are different, but this is a well-known trademark. Yes, protection. That is the essential difference, and this is a judgment which has been ultimately followed in many, many subsequent judgments, and it is still holding the field today. So far as these words are concerned, of course, there have been limitations in this. For example, as you've seen, the words of Indian gods and goddesses, religious texts are not allowed to be used. Now, in this case, the word we are concerned with is Vasundhara. Vasundhara, as you know, it means the earth. Now we will refer now to a Delhi High Court judgment, quite a recent judgment of 2023. This is reported in 2023 Supreme Court Cases Online, Delhi, 4185. Just read what is the case about. The plaintiff company was established in 1999 under the name and style of Vasundhara Jewellers Private Limited, and has been continuously and uninterruptedly using the name Vasundhara Jewellers since then as a trade name and a trademark. Then the plaintiff first adopted the trademark Vasundhara in the year 1999 for jewellery in precious metal and gems. Plaintiff uses several manners of representation of its trademark Vasundhara and has registration in its favour in class 14. Now after that, this is the conflicting mark. Around June 2019, the plaintiff came across the Vasundhara marks being used by the defendants. So both were using Vasundhara. Now I'll just read two paragraphs, paragraphs 25 and 26 of the judgment. This is how the court goes about discussing the subject. It refers to it says Vasundhara is a generic or common word, and there are several registered trademarks with the mark Vasundhara, therefore not capable of registration in the first place. Proprietor can claim exclusive right on the mark only after establishing exclusivity of the mark with the business of the proprietor on account of extensive usage. High turnover of the plaintiff because of products being of high value cannot be a determinant factor for establishing reputation. Exclusive monopoly cannot be claimed on the mark Vasundhara on account of registration of the composite mark, including the aforesaid mark, because the registration was obtained on Vasundhara, I think, Jewellery Private Limited or something like that. As regards the contention of the plaintiff that the mark Vasundhara has acquired exclusiveness on account of long user, in my view this aspect can only be examined in a trial, and it cannot be the basis for grant of an order of injunction. Then the two marks are compared, and then the court comes to the conclusion in paragraph 30. The comparison of the above would show that there is a difference in the spelling of the marks of the plaintiff and the defendant number one. The plaintiff uses the word Vasundhara, while the defendant number one uses an additional A, Vasundhara. Undoubtedly both the marks are phonetically identical. However, apart from the difference in the spellings of the marks of the plaintiff and defendant number one, the manner and style of writing is also completely different. The plaintiff itself, in its reply to the examination report of the Trademarks Registry, stated that there is no similarity and therefore the same would not create any confusion. In my prima facie view, the marks, when compared as a whole, bear no deceptive similarity to each other and hence would not create any confusion. Now, the reason why it says would not create any confusion is that it is a label mark, and you will find that the labels are compared side by side and there are photographic representations of the labels given in 29. So what does this judgment recognize? This recognizes as Vasundhara as a word mark cannot be registered. But Vasundhara in its label can be registered, because when you look at the label, applying the principle of section 17, you are looking at the label as a whole. And when you look at the label as a whole, and since you can't bifurcate a mark, and the label mark must be considered as one whole mark, and you compare the label of the offending mark side by side, and you find that these labels cannot be said to be similar. Although they are phonetically similar, the labels cannot be said to be similar. You can't say that there is similarity. So two things here. One is that if you look at the word mark, similar. If you look at the label mark, dissimilar. Because there are essential features of the label mark which are dissimilar from each other. So even though there is a common word, ultimately, even if you can't seek exclusivity over the word per se, you can seek protection of the label. I can say my label cannot be copied. And here the court said that no, I don't find there is any copying of the label because the labels are dissimilar, although the use of the word in the labels is the same. One last judgment on this aspect, also a Delhi High Court judgment. This is reported in 2010, SCC Online, Delhi 3806. Here the question was, again similar. I shall read paragraph 7. The two basic issues arise for decision in the present appeal along with identical and related issues. The first issue is on the aspect of infringement, that is whether the appellant's registration gives it exclusive right to use the subject trademarks low-sorb and low-sorb, and consequently whether an action for infringement is maintainable if a person such as the respondent uses a trademark which is deceptively similar or nearly identical or identical to the registered trademarks. Included in this first issue is the aspect whether the registration only confers prima facie validity and thereby does not prevent the court from denying the injunction in spite of registration. The second issue is the issue with regard to claim of the appellant pertaining to passing off, and the issue is whether the respondent's user of the expression low absorb technology in relation to its edible oil product amounts to passing off of the goods of the appellant which uses the unregistered trademark low absorb. This is the discussion. In view of the judgment of the division bench in Kerala Healthcare, and with which we respectfully agree, the appellants in the facts of the present case can have no exclusive ownership on the trademark low absorb. The expression low absorb is quite clearly a common descriptive expression or adjective. The expression low absorb is not a coined word, and at best is a combination of two popular English words which are descriptive of the nature of the product, as held by the division bench in Kerala Healthcare. That such adoption naturally entails the risk that others in the field would also be entitled to use such phrases. Low absorb is not an unusual syntax, and the same can almost be said to be a meaningful part and sentence or phrase in itself. The expression low absorb surely and immediately conveys the meaning of the expression that something which absorbs less, and when used with respect to edible oil, it is descriptive in that it refers to less oil being absorbed or low oil being absorbed. Similar to the expression sugar-free, being not an unusual juxtaposition of two English words, the expression low absorb equally is not an unusual juxtaposition of words in that the same can take away the descriptive nature of the expression. The expression low absorb is used in the functional sense for the character of the product, which is edible oil. With respect to the unregistered trademark low absorb, we are of the firm opinion that in a sense the expression low absorb only describes the characteristic of the product edible oil, and ordinary anomaly is incapable of being distinctive. Then it goes on to detail this further, but ultimately what here is a case that you use low absorb, it is descriptive of the character of the product, and so incapable of conferring distinctiveness on the product per se. So one, we have the name, Vasundhara, where the name is not a distinctive name because it is the name of the earth. And one is the name or the character of the product. You use low absorb, like the example is sugar-free. Is sugar-free capable of registration by itself? No. So similarly, the court held low absorb is not entitled to protection of registration. So when a person comes up with such names and such trademarks and seeks a protection against others who are using same or similar, because the offending mark was low salt. So therefore the question is whether you will be entitled to protection. The court held said no. In such circumstances you will not be entitled to protection because ultimately there is nothing in it which distinguishes the product. So whether you look at it from the perspective of infringement or the perspective of passing off, there is nothing distinctive. If there is nothing distinctive, how can you say it's being copied? That is the essence of the whole thing. I don't really know whether, are we also continuing post-lunch or no? It's a lot of subject to cover, so I'm wondering how to go about it. No, what I'll do in that case is I'll just give you with the note, leave you with the notion and some judgments that I would like to say, but I don't think I'll have the time to say them. So, on the pricing, there are judgments which says that in this case, there was a question of pricing of the product. And this was also a case of gold flake. So I'll just give you the citation where pricing of the product compelled the court to believe that no, you can't classify them as one being ultimately capable of confusing the purchaser with the prospective purchaser of the other class of goods. This is 2011, SCC Online, Calcutta, 518. I'll just read the one paragraph. I think we still have just a little time. The immediate theatre of conflict arises upon the plaintiff's perception that the second defendant has altered the get-up and packaging of its special brand of cigarettes to mimic the metallic red and flaming gold packet of the plaintiff's gold flake brand of the same class of poison. The plaintiff suggests that in the second defendant's recent adoption of the pattern of color combination and writing in respect of the packaging of its special brand, there is apparent dishonesty in trying to creep up to the appearance of the plaintiff's hallowed brand and appropriate the goodwill that is exclusive to the plaintiffs. The plaintiff concedes that the name of the products are not identical, that the pricing of the two products are in different bands, and that there are other features suggesting this similarity, but insists that it would be customer of the plaintiff's gold flake brand that has every likelihood of being confused at the sight of the second defendant's special packet. Then both the packets are considered and says that the prominent feature of both the packets is actually the statutory warning more than the cigarette packets themselves. And then it says the test at the end of the day is still in the eye. As to whether the get-up of one product is a copy of another cannot be told by placing the two products side by side and counting either the similarities or the differences. The more trustworthy assessment would be to remember the plaintiff's product and view the defendant's. If the eye reminds one of the plaintiff's products upon looking at the defendant's, not only because of the similar color combination but also the impression of the other distinctive features, an injunction may issue. If a fleeting glance at the defendant's product throws up images of the plaintiff's product, the test is met. If the eye does not recall the plaintiff's product upon a look at the defendant's, injunction has ordinarily to be refused. And then the court says upon comparing packet to packet that there is no injunction because the test of recall, immediate recall is not there, not satisfied. So this also considers the brand and the pricing range and looks at the immediate recall features. It says ultimately you can't really count the similarities and dissimilarities and come to the conclusion. More practical way of looking at things. Some cases on how disclaimers operate. You can make a note of 2018, volume 16, Supreme Court case 632. Now this judgment becomes important along with other judgments in the field. There are two judgments which are relevant. Now in this case, the word in question was Malabar. It was being used in respect of biryani rice. Now Malabar, as you know, is a region, and that region is also famous for various rice growing and other kind of growth. Here the court found that you can't seek exclusivity over the word Malabar. But it says that yes, there are other features of the packaging which you seem to have copied. So obviously the intent is to ultimately cash in on the product. And then said that we are happy if you change the font and the manner of writing of your mark, then we will allow you to sell Malabar. I'll just read this thing. Appellant sold biryani rice with the label mark using the word Malabar and was granted registration under class 30, but with a disclaimer that the registration of the trademark shall give no right to the exclusive use of the word Malabar and all other descriptive matters. It was held that the appellant had no right over the exclusive use of the word Malabar since there was a disclaimer. In the present case, the interim order of the High Court in the suit for infringement and passing off filed by the plaintiff, entitling the respondent to use the word Malabar in conjunction with Boroma with the different get-up as approved, is upheld. So what the court often does when it comes to a conclusion that no, I get the impression that you are trying to actually unfairly adopt a trademark that belongs to others, distinguish it sufficiently so that that confusion is removed. So in case of Malabar, initially an injunction was granted. Then the court said, are you prepared to distinguish it? Yes, we are trading under the name Baroma also, so they said Malabar Baroma. And they said so far as the writing and the manner of depiction in the packaging is concerned, we'll also change that. So the court upheld that. And ultimately the matter was taken up in challenge before the Supreme Court, and the Supreme Court said no. Now that you have sufficiently distinguished it, I see no reason for granting an injunction. Because you can't claim that Malabar is your own property, exclusive property. The second case, which is also very important in this regard, is Ayur. In this case, this is, I just give you the citation again. It is again 2010 SCC Online Calcutta 134. Now the trademarks were Ayur and Ayu. Now Ayur, as you know, is an abbreviation of Ayurveda. And Ayu is the depiction of the span of your life. Now none of these by themselves would be independently capable of distinguishing a product. Here there was of course long and continuous use of Ayur, and here this is what the court said. Reflecting of section 17, section 29, etc. I'll just read a small part of the judgment. As regards the injunction based on the doctrine of passing off, we find that the learned judge came to the conclusion that by using the mark Himani Ayucare, there is sufficient bona fide attempt by the defendant to avoid confusion of that plaintiff's use of the word Ayu. And as such, the learned single judge held that the defendant would be entitled to use Himani Ayucare, but should not use only the word Ayucare without the word Himani. Then reference is made to the decision of Kaviraj Pandit Durgadhan Sharma, which I have placed. And then the court goes on to say, no doubt, where the evidence in respect of passing off consists merely of the colorable use of a registered trademark, the essential features of both the actions might coincide in the sense that what would be a colorable imitation of a trademark in a passing off would also be such in an action for infringement of the same trademark. In an action for infringement, the plaintiff must, no doubt, make out that the use of the defendant's mark is likely to deceive. But where the similarity between the plaintiff's and the defendant's mark is so close either visually, phonetically or otherwise, and the court reaches the conclusion that there is an imitation, no further evidence is required to establish that the plaintiff's rights are violated. Expressed in another way, if the essential features of the trademark of the plaintiff have been adopted by the defendant, the fact that the get-up packaging and other writing of the marks on the goods or on the packets in which he offers the goods for sale show mark differences or indicate clearly a trade origin different from that of the registered proprietor of the mark would be immaterial. Then he says, we are required to consider whether the learned single judge considered the above case. And then finally, he says, the plaintiff cannot claim exclusive right over the word Ayu, meaning longevity, and similarly over the word Ayu, denoting its connection with Ayurveda. We have verified the design, getup and color combination of the products placed before us, which have no similarity with those of the plaintiff, and we have reasonable doubt to infer dishonest intention of the defendant to pass off its goods as that of the plaintiff, as would appear from the fact that it has further added the prefix Himani prior to the word Ayu or Ayurveda. The defendant, it is needless to mention, has also not used the peculiar style in which the words Ayu or Ayu is used by the plaintiff. However, in the absence of the added prefix Himani, there is definite scope for confusion. So the court says you can't use Ayu and you can't use Ayur. But nonetheless, even if you are not entitled to protection under the provisions of the Trademarks Act to the words Ayu or Ayu by themselves, because there has been continuous use, and you can't say that don't use it or stop using it. Today, when the subsequent user distinguishes it with the use of a suffix or a prefix, in this case Himani Ayuke, it says then the confusion is avoided. So the courts, while considering these matters, very often say that yes, there is apparent confusion, but if you are prepared to remove the confusion by altering the label or by adding a suffix or a prefix to the mark, then that can be ultimately the solution to the problem. The matter goes on, but I think what we can do is now stop for and ask for a few questions if you have any, because it will actually not be possible to cover the entire range, and I have not even touched upon the Designs Act or the Patents Act. So
if you could just touch on the jurisdiction. Now
Yes.
that the Commercial Courts Act has come.
yes, now the question is that if you look at Section 3 of the Commercial Courts Act, then ultimately if it concerns a trade or a business, it would fall within the ambit of Section 3. If it falls within the ambit of Section 3, it is only the commercial court that can use jurisdiction. Now if you look at, there is one provision, I don't know whether it's Section 134. Please have a look at Section 134 of the Trademarks Act once. I hope I'm talking about the correct section. Yes. This is the provision, jurisdictional provision in Trademarks Act. It says no suit for infringement of a registered trademark or relating to any right in a registered trademark or for passing off arising out of the use by the defendant of any trademark which is identical with or deceptively similar to the plaintiff's trademark, whether registered or unregistered, shall be instituted in a court inferior to a district court having jurisdiction. Now the question is, what is the court that will have jurisdiction? So the district court is the court where it will be instituted, and then it says, for the purpose of clauses A and B of subsection 1, a district court having jurisdiction shall, notwithstanding anything contained in the Code of Civil Procedure, which means notwithstanding the provisions of section 16 to 20, which talks about jurisdiction. The district court having jurisdiction shall, notwithstanding anything contained in the Code of Civil Procedure or any other law for the time being in force, include a district court within the local limits of whose jurisdiction, at the time of institution of the suit or other proceeding, the person instituting the suit or proceeding, or where there are more than one such persons, any of them, actually voluntarily reside or carry on business or personally work for gain. And here, explanation is, for the purpose of subsection 2, person includes the registered proprietor and the registered user. Now pausing here for a moment, normally when we talk about civil actions, we say that it is the defendant's place of residence or the place where the defendant carries on business which will confer jurisdiction. And Here the departure is made because here it says that a district court, and it can be at the plaintiff's place of carrying on business. Now why is this? Why is this so? Why is departure made? Because you will find that today there may be an infringement of a particular product of the plaintiff in 16 states of India. Now which court do you approach for that? Prior to the amendment, it says that you will follow the principle of the Civil Procedure Code. It is a place where the court would have jurisdiction on the basis of section 16 to 20 of the Civil Procedure Code. That is the place where the defendant resides or carries on business. But the amendment in section 134 now, which is brought about, says it will be at the plaintiff's place of residence and business also, because of the practical difficulty in a plaintiff going and filing 16 suits in 16 states where his mark is being infringed. Now, today, so far as the district court is concerned, by reason of the application of the provision of the Commercial Courts Act, it will be the commercial court of the district which is vested with the jurisdiction.
Because like I as a CGM, I also have a commercial court. So
Yes.
this is particularly of the district.
Yes, that's right. So I hope this section answers the question. Anything else? If there are no questions, then can we close the session? I find that this is a very, very young judiciary here.
Yes.
So I was expecting a lot more questions. And if there are no further questions, we can close the session.
Yes.
Sir. Thank you. Thank you so much. Thank you for so very patiently bearing with me. I'm sure it's not easy to be here on a Saturday.